All right, Chair, we are live.
Thank you very much, Ms. Jones. I will now call to order the May 8th, 2024 meeting of the Sentencing Commission's Misdemeanor Subcommittee. Good afternoon. Good to see everybody here, and welcome to those who are viewing on the Department of Sentencing Policy's YouTube channel. This is the second meeting of our current biennial meeting cycle. I'm going to now ask Director Powers to take the roll, please.
Thank you, Chair. John Arascata. Judge Steve Bishop.
Present.
Christine Jones Brady.
She let me know that she wouldn't be available and there would be a representative for the AG's office attending in her stead.
Perfect. James Conway.
Here.
Chief Judge Cynthia Cruz.
Present.
Wes Duncan.
Here.
Jack Essinger. I see him, marking him present. Nick Graham.
Present.
Evelyn Grosnick.
Present.
Eve Hanan.
Present.
Chief Judge Kevin Higgins.
Present.
Dr. Jennifer Lancherman.
Present.
Christina Mortensen.
Present.
Lisa Mosley Sales.
Here.
Michael O'Brien. John Puro.
Here.
Marcy Reba.
Present.
Elisa Schultz.
Here.
Holly Wellborn. Chair McCormick.
I'm here, I think.
Perfect. Chair, we do have a quorum.
Thank you, Director Powers. The next item on our agenda is public comment. And this is the first period of public comment. There are two periods of public comment, one at the beginning of the meeting and one at the end. Members of the public have two options for submitting comment. First, you may do so in writing by emailing the Department of Sentencing Policy at sentencingpolicy@ndsp.nv.gov, and public comment received in writing will be provided to the subcommittee and be included by reference in the meeting minutes. Members of the public who wish to testify may also do so by telephone. Due to time constraints, public comment will be limited to 2 minutes. Any member of the public that exceeds the 2-minute limit, can't say that, may submit comments in writing to NDSP at that same email address. At this time, I'll ask staff to manage and direct those who wish to testify by telephone. Turn over to you, Ms. Jones.
Thank you, Chair. Members of the public who would like to testify by phone, press *9 to raise your hand. When it's your turn to speak, please slowly state and spell your first and last name. And it looks like no one wants to be participating in public comment today.
All right, well, with that, we will close the first period of public comment and move on to agenda item number 3, which is approval of the minutes of our last meeting. Members of the subcommittee have been provided with copies of the minutes from the March 22nd meeting. Are there any comments, corrections, or concerns? Hearing none, I will entertain a motion to approve the minutes from the March 22nd meeting.
So moved.
I have a motion from City Attorney Duncan. Do I have a second?
Second.
This is Jack Esslinger. I second.
Sorry, I didn't catch who seconded it. Could you repeat? I apologize.
Jack Esslinger, seconded.
Oh, thank you, Jack. We have a motion from Mr. Duncan and a second from Mr. Eisingler. Any discussion? All right, all in favor? Raise your hand or somehow indicate. All right, anybody opposed? Hearing no opposition, the motion passes and the minute meetings, wow. meeting minutes, that's how that word order goes, are approved. All right, the next item on the agenda is what we're referring to as misdemeanor statutes to recommend repealing or modifying. So the charge of this subcommittee is fairly broad. And my thought with putting together this list that was included in the meeting materials was potentially this would be a way to sort of start framing it and begin the discussion on perhaps recommending to the Sentencing Commission for the repeal or modification. You've got what is basically a 2.5-page list. It is in numerical order in that left column. In going through this, I did stay away primarily from like the regulatory body misdemeanors, because my thought on that was that's a conversation to have with the medical board of whoever, the cosmetology board or whoever that is on those misdemeanors. But just in my review going through here, a lot of these seemed sort of old and outdated, and that maybe we didn't need them anymore. And I thought that maybe as a group, we could potentially agree on making this recommendation and kind of chalk that one up and then move on to, I think, what more of our task is, which is really digging into sort of the misdemeanor structure and everything surrounding that. But again, like my rationale on this one, for example, NRS 2.250 and 2.55, those are the statutes which say if my colleague Elizabeth charges more fees than are allowed by statute, it's a misdemeanor, which kind of seems to me to be unnecessary at this point that we have that expectation. Again, the next one on there, if a district judge accepts a gratuity for performing a marriage, that's technically a misdemeanor, and we do have the constitutional and statutory structure of the Judicial Discipline Commission to handle those type of issues. And then again, and some of this, it's not saying that, for example, a justice of the peace should not keep their fee book open to public inspection. But if, say Judge Higgins, because I always like to pick on Judge Higgins, were to hide his fee book, I don't necessarily know if that is a matter for criminal prosecution with a potential penalty of up to 6 months in jail. Not saying that perhaps there are people in Washoe County who may not want to pursue it. But so again, that was sort of the rationale on a number of those, were the unauthorized fees and stuff. And that, again, in the notes column you see on that spreadsheet, there's my notes, such as that JP keeping the fee book open, that was added to NRS in 1883 and has not been substantively amended since there. Professor, I see you got your hand up, and then Lisa.
I think Lisa may have had her hand up first, but I can go ahead. Either way is fine.
Right, you just she happened to be on the left side of the screen, and you were more in the middle.
I know.
Your hand
Teaching on Zoom during the pandemic, I know how hard it is to keep track of like everything, that the hands and all that. I guess I just am interested in just taking a step back a little bit and understanding the process of it, arriving at this list. And I really appreciate the effort that you've already made here, and just wanted to understand, you said a little bit about your criteria for inclusion, which was if something seemed old or outdated, but does that mean that, I guess I thought our job was going to be more to think about what the priorities are and think about criteria for recommending repeal or amendments. And it sounds like this is recommended for repeal and amendment based on being old or outdated, but does this mean you've gone through all of the list of 80 pages and these are the ones that aren't used? Is there data on how much they're used? And so is this maybe the cart before the horse? Should we be talking about what our priorities are? If they're certainly like cleaning house, things that aren't used would be removed, but maybe things that are also having an outsized impact on certain communities, things that are unfairly applied, things that might be disproportional. Is there a systematic way to approach that? I'm just a little bit, yeah.
Right, and I certainly appreciate that. And that was part of my struggle in figuring out how to sort of get this train rolling. So from what I decided to do in producing this list is go through, and this was my call on these. There's no, it was not a systematic thing, but I went through that full 85-page list, and these were the ones that stood out to me as being, So I kind of did a test on these, and maybe if the group doesn't want to approach it that way, that's fine. But I was trying to give us a starting place, because I do certainly think our task is, as you have iterated, that it's really to dig into it and find the misdemeanors that are charged frequently and do have that disproportionate impact or are somehow problematic. And again, my thinking on this, and obviously I'm not the end all be all, was that some of these just seem sort of silly to have in statute. And frankly, my thought process was, this gives us a solid recommendation to build off of. But again, like, this is all open to discussion. I'd certainly like the perspectives of the people working in the system, doing the charging, doing the defending. Again, if I can refer to one of them on the list, 199-270 makes it a misdemeanor for a citizen to refuse a command request by an officer or magistrate to make an arrest or assist in an arrest. And to me, that just seems so outmoded that we would have a misdemeanor on the books that potentially a citizen of the state could be charged with for refusing an order from a law enforcement officer to assist in that officer making an arrest. To me, that seemed like that's a huge liability issue on the agency side and those kind of things. So that, again, was my thought process, and I'm not articulating it. Please ask. But again, that was kind of the idea. And I guess maybe it was like, for lack of a better term, it would kind of gives the group a win to build off of and move forward, because I certainly think, and the next agenda item, I think, is where we're really going to start digging into it and seeing those data and what data we can collect and what it supports, and if we identify any of those trends. And then, based on my experience from having worked in this field for some bit of time, generally we end up having a conversation about public safety and those type of things. And so I thought, again, moving forward, if anything on this list appears that it shouldn't be on the list, we can certainly do it. We can certainly scrap this list and start over too. Like, none of this is set in stone or my way or the highway type of situation. But that was sort of my rationale. And I mean, some of these statutes, to me, again, not making an official determination, seemed that they may have some facial constitutional challenges, rather than, I think, the ones that we're going to need to dive into to see if the application, et cetera, is presenting that challenge, if that makes sense. Lisa?
Thank you, Chair. I echo some of Eve's concern. I think she might be psychic. We have some of the same concerns. I certainly appreciate your thoughtfulness and how you've gone through this list and thought about that. I don't think there's many on here that we all wouldn't agree probably shouldn't be. My concern is that we're sort of putting the cart before the horse and making the recommendations when we haven't established what the mission. I think we all know what the mission, but just in writing, what the mission of the subcommittee will be, what the criteria will be for recommending removal, repeal, decriminalization, legalization, and just having some processes in place. So even with this list, like, you've come up with this list, what would be our process for deciding on whether we move forward and suggest repeal for all of these? So that's my concern, is just how are we, the structure of the group, what is the criteria that we're going to use to make recommendations? What is going to be the process for data collection? And thinking that all of the recommendations that we make are going to be data driven and data informed. So just wanted to, and we don't have any data on any of these. I know you went through and you looked at all of them, and it's crazy that some of them are like from the late 1800s or early 1900s, of course, and haven't been used but we'd like to know that, like, what is the data on any of these? Have they ever been charged? Have they ever been used? Who's been charged? How were they adjudicated? So thinking about that and establishing those things first before we move forward with making any recommendations, that would be where I would want to see us go as a subcommittee.
Point well taken. With that being the case, I think, sorry, I have a million files open here on my desktop. That being the case, and maybe I'm out of order, so to speak, in the agenda order, in having that list, and maybe we table this and we look at it later after we have some more of that discussion, because subcommittee data requests, and maybe that's not the most articulate name, but it's like there's so much information and data to collect on this. And am I breaking the open meeting law because I'm jumping around here a little bit? Somebody slap me upside the head if I am. But it does sort of bleed over into agenda item number 5, and maybe that's what we need to talk about is data, because as you've indicated, we want to be data driven, but I think we have to define the data we need to drive us and what data is available now, what data is available then, and kind of systematically look at that. So, I mean, I'm not married to this list in any way, shape, or form. Again, a lot of it was just like, really? Apparently, for those of you of the male gender on this meeting, if a firefighter comes to you and says, you shall assist me putting out this wildfire, it's a misdemeanor if you don't assist, but they can only do it 5 times during the year. So, that was some of mine, was maybe trying to get some of that sort of, I don't know, for lack of a better term, silliness out of the way. But again, if the will of the committee, because this is a committee and we're here to study this together and figure it out collaboratively, is to start talking about the data to drive it, I'm happy to do that discussion now, and we can certainly table this and come back to it later after the group is more comfortable with sort of criteria or direction or whatever. And again, like, I don't think I'm speaking out of turn here, but our charge as a group is so big that I was trying to figure out a way to start, again, like I indicated, start that train down the track. So Lisa and anyone else, and I think we got Lisa and then Judge Cruz and then Judge Higgins.
No, I was just going to offer my support for your thinking on this, that we start somewhere. And there are some of these are so outdated. Some of them are almost funny. But again, I think moving forward, it's like, if we all agree that these should go, then what is the process for that? Let's at least establish the process for whether we all agree or not, for the ones that we don't necessarily need data for. Some of these are just so old. Do we really have to try to dig to see when someone was charged with these and how long ago, what the adjudication was? But I think having a process in place for that would make a lot of sense, even when making recommendations for a list this early. That's all.
Appreciate that. Judge Cruz?
I think that what we're talking about here is, I think your list helps us start, not that we're saying we're approving this list, but I think it starts the discussion, as it seems like one of the areas that we should have on our criteria to look at is statutes that appear to be so antiquated or old that they're not with how our society and our communities have evolved and developed, that they would be, 1, not even applicable, or 2, not even used. And that could be just one piece of our criteria to start working on developing what our criteria would be. And I think that might be where you're going to hear, and that's what I seem to keep hearing, where your thought process was, Chair McCormick, and what everybody else is kind of also doing. We need to establish our criteria, but maybe this is one piece that we have as one of our criteria that we look at.
Thank you, Judge Cruz. That was a very nice articulation of that, I think, because I was kind of, stumbling around. And I think after Judge Higgins goes, we've got Judge Bishop. But real quick, first, Judge Bishop did comment in the chat that some of these appear to be pretty low-hanging fruit, and maybe that's where I was coming from, like that aspect. But Judge Higgins?
Not to belabor this, but unless a group like this asks to have these repealed, no legislator is ever going to waste a bill draft getting any of these repealed. But then you run the risk, if I fail to help the sheriff stop a riot, I have committed a misdemeanor. The statute from 1868 requires the justice of the peace to assist the sheriff, and you shall appear at the riot and disperse the riot. And if I don't, that's silly, but all it takes is one DA that doesn't like one JP, and all of a sudden somebody's being charged with something. So I don't think this is probably the most important part of our process, but unless we say, here's a list of these 87 things, no, it's never going to get fixed unless we do it. So, and frankly, I can't imagine there's any data on this anywhere. Because unless there's a knock code for these, and I am willing to bet these don't have any knock codes. Unless there's a knock code for these, there's no way that the data was ever kept in the first place.
Appreciate that, Judge. And I think the last thing this group wants to do is dig into knock codes too much. We've got Judge Bishop next, and then Ms. Grosnick.
Judge Cruz kind of touched on it, but as she was talking, I was thinking about it. If we play around with this low-hanging fruit list, and we get in a group of maybe a dozen or so, 2 dozen of these are silly and we need to get rid of them, we might be able to identify some common criteria amongst them to help us build a framework to address some of the harder stuff. So I think it might be worth playing in this area a little bit. And if nothing else, it's kind of funny.
Yeah, the one about transporting indigent people between counties in this state sort of blew my mind, to be honest. Ms. Grosnick?
Thank you. I was just going to chime in. I really appreciate all the work that went into this list. Also, last time we talked about some bigger areas. I think last time was sort of a brainstorming session where we talked about sort of things that people thought might be an issue where we should focus our data inquiries or make those recommendations. And so some of those big topics were, using fines and fees, assessments, should the courts be reliant on them? Are they disproportionately impacting vulnerable populations, the citable offenses versus arrestable offenses, and do we need more clarity on that? And then I think I'm vested in this topic, but we did go into the impact on public defense also. So I think it might be helpful if we just kind of take a look again at what was on people's minds last time as big topics of where to start data collection, because we also have some people at this meeting that we didn't have last time who might be able to answer questions about what data we can collect.
Thank you. And again, the next agenda items on that one. So, if we want to have that discussion prior to looking at the, sort of silly Civil War era statutes, we can go ahead and table item 4 and then move on to the data request and sort of let that conversation see about driving it, if the group is more comfortable with that. Not seeing any objection. We can table agenda item number 4, and then we'll come back to that at some point in this meeting or a future meeting and discuss after we've maybe thought a little bit more about criteria and data points. And with that in mind, Director Powers has put together a list regarding some of the issues or challenges or concerns or whatever we want to call it with collecting that data. So I'm going to ask Director Powers to share her screen and start talking about data a little bit.
Thank you, Chair. Georgia Powers, Executive Director, Nevada Department of Sentencing Policy. I'm going to share my screen. Real quick, I'm going to introduce Jenna Bonacorsi. She's the Deputy Director at NDSP, and she is our data guru. So I may be calling on her a bit for some of this, but wave to us, Jenna. Thank you. All right. All right. So what we did was put together, when we were doing minutes for the meeting, we put together basically a 2-page document of everything that people asked for, data that we thought we might want to collect. And basically it came down to what's on this page, at least a good starting point. So it all fit into these categories: which misdemeanors are being charged and punished. Everybody wanted to know what was jailable. Should we be restructuring these? Maybe have a hierarchy like we have for felonies in Nevada. Are the punishments that are currently being used, are they reasonable? If we have a hierarchy, where would we place loss of liberty and arrest and being jailed? And what are the collateral consequences of these punishments? And then the next area would be demographic data. Who is being charged, especially the lower end misdemeanors? Can we track mental health as a demographic data point? And where are these things happening? Where are they being charged? And how do the sentences look as far as disparity throughout the state? And then probation information, which offenses require or allow alternative sentencing. And then there were a few mentions of probation tails. And why? Are we talking about public safety? Are there other reasons that these tails seem longer than they might need to be? Fines and fees, determine collected versus outstanding as far as fines and fees. Are they serving the objective that for their original use? What was that? And then again, collateral consequences of these fines and fees. And then the last subject would be defense. Can we track the attorneys that are appointed, and are they being charged? If there's things that were important to you that were left out of there, let me know. We can add to this. But this would be a starting point. Some of this data is available. Some of it will be available to be sampled from different places. I'm going to go back to the discussion you were having about this list, or the whole 80-page list. We have information from RCCD, and we can pull things out from 2017 to 2024 at this point. Can I tell you if something was charged in 1896? Probably not. But we definitely can get started on what we have from 17 to 24. And as this subcommittee makes their decisions and tells me how they want to move forward as far as data collection, we can take 10 pages at a time, and I can tell you from the years that I have how many were charged, how many were convicted, and what happened from there. So that's a start that I'll give you, and I'll let you discuss what you might think comes next.
Thank you very much, Director Powers, and I think that's a good way to do it. And I think we do need to, and my intent with this agenda item was to kind of funnel that down, because as I indicated, there's a lot of data in a lot of places, and we are, NDSP is limited in time and resources, so it's distilling that down. And I think George has done a pretty good job of doing that for us here with this list. I just grabbed the annual report of the Nevada Judiciary because, I have copies of that all over my office, if that's an indication of anything. But last year, there were just about 100,000 criminal filings in justice and municipal court. So that's sort of the scope, but that also would then include prelim stuff, the felonies and grosses filed into justice court initially. Sorry, I got it. Oh. Sorry, I'm fiddling with my view here. There we go. Yeah, so thoughts on that? Do we want to, that's a lot of homework for the members of this group, and I don't know what the potential appetite or capacity, honestly, for people to do that is. Do we want to go through the list and pull ones? Do we want to ask, NDSP to take apart and pull that data to the best of their ability? Again, this is where we go from here and how we get started, because that's been my struggle, is figuring out how to tackle this giant monster. Professor, you have your hand up?
Yes, thank you, Chair McCormick. And I also want to let you know that I do like your list, and I will probably use it in my criminal law class. Right now, I have a list of some federal crimes I share with the criminal law students, which include pulling the tag off of a mattress being a misdemeanor. So I'm all for having a doesn't pass the laugh test as part of the criteria as we move forward. I'm wondering if our discussion of working groups would fit with this discussion that we're having now, and the thinking of like contribution from the law school or from me in the first category, which is more about the definition of the laws and the punishment, how it's structured, how other states structure it. That would be the kind of data that I would think would be like the law school institutional contribution could be to a certain extent. So I don't know if this is the time to talk about things in that way. I just wondered if there was interest. Different folks here have interest in different areas and that might help guide the work and help us think it through.
Yeah, thank you for that suggestion. I think it's a great idea because, again, this is a big task that we've got here, and doing the multi-cert surveys of other states and how they do it. And I personally would be particularly interested in the classification systems, if they have multi-level classification systems in other states, because in my mind, if we can come up with that classification system, and Lisa, I see hand up, I'm just going to yap a little bit here. If we can come up with that classification system, does that help us frame it and say that, I'm just going to make something up, that class A, B misdemeanors are loss of liberty misdemeanors, are arrestable, category C, D aren't, category E are citation only, like however that is. Maybe that's a way to begin looking at it, and that could be informed. Because this is not a disparagement or anything, but because of our constitutional structure on our legislature, we have kind of a unique, we add to statute quite a bit, but never really sort of subtract. And so maybe that's a way to approach it. Lisa, you had your hand up?
Yes, Chair, thank you. I was just going back to some of the data points that were listed on the sheet and just wanted to make sure that we were thinking also about, when it fines and fees in particular, assessment. We add on their collection and what's outstanding, but what's also being assessed. What I've learned is that there are fees and that some courts assess that other courts don't, and also the case with some fines. And just making sure that we add the assessed data point, and then with the demographic data, adding some of the other things, age, race, all of those things. I think that will inform our work down the line when we make the recommendations for what reforms we want to see, and the recommendations we want to make to the legislature, and also where we're getting the data from. So initially, when we were thinking about this, we're thinking about it getting data from the district level, justice level, municipal court, law enforcement agencies, jail data, prosecutor data. And I know, don't yell at me, everybody, that's adding to our already gargantuan task. But I think it's important to make sure that we are thinking about the data from all of these places, so that when we come to the point of making the recommendations for reform, that we have done our due diligence and we're not overlooking any particular part of this. So just wanted to point that out.
Thank you. And I certainly agree that the more data we have to inform the process, the better. My concern is the sort of feasibility of collecting data and starting in a place where we can get it. Like as Director Powers indicated from our CCD, they've got that. They've got the reporting of all the reportable misdemeanors, so that may not necessarily include some traffic misdemeanors. But we have a limited amount of traffic misdemeanors now. And Professor, if you want that list, I think I got it somewhere too. Yeah, so like, I guess that's the tool point, is like perfect world, all the stuff we want, and then how we begin approaching that. And then I think the work group idea is good too. And I will admit that I've had a hard time wrapping my head around how to funnel this down. And I certainly appreciate everybody's suggestions. on that one. Director Powers, I don't know if you're comfortable commenting like on what data we can get now without, upsetting or not upsetting, but like a ton of stuff and that kind of thing. And one other quick point on the data, the last session, the legislature did include the potential for a new position for NDSP to assist this group in collecting some of that data. And I believe we'll be pursuing that at IFC in June, if I'm not mistaken.
That was pushed on. The last I talked to you, yes, it was June. Between our budget analysts at ASD and GFO, we are now going in August for an October 1st start date. So right now we're using our current staff to do anything that needs to be done and collected and analyzed and such. So.
And then I see Judge Higgins has his hand up. Maybe not. Might have been an inadvertent hand.
Sorry, I was getting telephone calls at the same time. I appreciate the need to track mental health status. I'm not sure how we're going to do that because it's not like there's a box to check that the officer is concerned about mental health status, or if somebody goes through an evaluation process and attached to a particular case, that's not something that, it's like, it's not date of birth, social security number, age. So while it's important to keep track of the mental health, I'm not sure what that would look like as far as tracking it. I think it's important. I think it's something else we have to wrap our heads around.
Judge Cruz?
So I'm going to chime in there, I think, and I'm sure Mr. Pirro would also really chime in. If we're trying to figure out, and a lot of the data points are going to come through potentially the court system, you would have to, are you now saying that you want us to have a flag in a case that somebody has a mental health issue, which I don't think I would agree, and that is just a liability issue for the court to make that judgment call, because, and then your next step is who's going to be making that determination? Is it, like Judge Higgins said, is it the officer? Is it the judicial officer? Is it a defense attorney? Is it that we're having them assessed? Is it that we're having them evaluated? I think it's a slippery slope, and I think it's very difficult for us to figure out, and we would spend a very long time trying to quantify that data point.
So if I may here, I think there are those difficulties associated with mental health. And I think from this group, I don't think I'm going out on a limb here if I say there is some consensus that mental health plays a significant factor in misdemeanor criminality or alleged misdemeanor criminality. But is that something that we collect the other data on first and then see how we can marry those up? Because as Judge Cruz indicated, I don't know how we're going to track mental health status and what's the criteria. And like Judge Higgins said, what's the criteria? The officer thinks there may be an issue, the defense attorney, the prosecutor, the judge, are we having them assessed? Is there an actual diagnosis? Then are we getting sort of hinky with that kind of information? So, but again, and that's, maybe incumbent on me, but I just feel like that we do need to sort of distill that down with what we can get and start building there. So maybe, and obviously just an idea, maybe we have, or we ask NDSP to go through and pull certain data points and bring that back to us so we can start there looking at it. Is that a foundation to build on? Or, again, it's how to begin to tackle this and putting together a list of criteria. We've got, antiquated, for lack of a better term, other, disproportionate enforcement. I think everybody was sort of on board with that being another criteria to examine in this. And then, so, do we let the criteria drive the data request? Do we let the data request drive the criteria? And again, I mean, we all have our own individual employers and roles, and maybe familiar with the data limitations or that kind of thing that exists on that end. And so, how can we best do this? Because as Judge Cruz indicated, for the Las Vegas Justice Court, which is clearly the highest volume justice court in the state, to come up with that criteria to track potential mental health concerns and then program it into their CMS so it flags and then determine the flag, and then that may not be the number one priority because it's a long-term thing. And I don't want to pour cold water on what we want to know, but I also want to make it so we can know something to inform our moving forward. Don't all speak. Oh, sorry, Marcy.
Thank you. Just going to the mental health, are we concerned about client confidentiality? I don't know how a court would be able to tag that and it wouldn't be imposing on that confidentiality of that client, especially regarding mental health. I think that if employers or other individuals learn that this box is checked regarding mental health, it could have long-term consequences that are harmful to our clients. So I don't necessarily know what the definition of that mental health would be, what the purpose is, or why would we be collecting it. I guess my question is, when we're proposing what data we're collecting, did we look at any sort of studies that make recommendations of what sort of data we could collect? Because I do notice that demographic data seems to be missing from that list. And I think in misdemeanors, that might be something very important for us to be tracking, as well as the demographics of the justice involved individuals. But I don't know why that isn't necessarily something that we would be tracking, because that seems to be in every police report and could be something that is very objective that we could enter in, where that mental health is more subjective. I don't know who's making that decision. I don't know how they're making that decision. So I would encourage us to use objective data of, things that we can all agree on is what we should be collecting, like demographics, human services. I think that would be helpful, whether they're coming from different areas, and jail data of whether they're being released or not. So those are just my initial thoughts.
Just quickly, when I put the heading demographic data, I was assuming regular demographic data. So anything on gender, race, age, things like that. I did not list them there, but of course, I assumed that I made the assumption that that would be understood. I apologize for that, and we'll add it to the list.
And then, and again, we have misdemeanor probation data on this list, and that's such a patchwork in this state, because there are a number of courts who don't have alternative sentencing or any other mechanism, and it becomes a status check with the court. So, yeah, again, I don't know, and maybe I'm at somewhat of a loss on this as far as how to start. I mean, is there, on that monstrosity of a list we have, do we want to just break that up by page and ask NDSP to collect data, or do we want to have a working group to identify the misdemeanors we want to look at for the data, or do we want to let the data drive the review of the list again? Yeah, it's
If I could, John, real
Yeah,
quick.
sure.
I hate to just jump in, but I've been trying for like 20 minutes to find the hand raising function on Zoom.
Oh, no
for some
worries.
reason. I can't find it for the life of me, so I'm just gonna have to butt in. At risk of just sounding contrarian, I don't really know how helpful data is going to be in making a lot of these decisions. I think a lot of this is just strict policy determination of, what conduct should be criminalized and what conduct shouldn't. I'm not saying data can't be helpful at all, but I've been in a lot of these committee meetings where we just jump right into, all right, we need to collect data, we need to collect data, we need to collect data. And we spend the whole time chasing numbers without ever actually making a determination of what we're planning to do with the information in the first place. So I don't know, you know, I can run reports in our case management system and kick out numbers and statistics to you all day long, but I don't know what it's going to, how it's going to help us make any decisions on what legislative changes need to be made. So I guess my point in all of that is, I think it makes more sense to just start with which misdemeanors, kind of starting where you sort of did, where just digging into the to the statutes as they stand as is, and see what changes we think need to be made, just independent of any data or statistical issues.
John, Hero?
I just wanted to push back on that point just a little bit. I agree with you in a sense that I don't think we should chase our tails seeking data, which our state is not a good keeper of data, to stop us from moving forward on the project. But I will say, well, I think I'm thinking forward. I think John is thinking forward, Lisa and other people who have appeared in the legislature, as Wes Duncan, who's also a former assemblyman, could tell you, you could try to tell the legislature what kind of policy you want to pass, but you got to have a little bit of backup to it if you want them to move anything in that building. Kind of how they did with AB 236 and CJI had a big report. I think it'll be incumbent upon us, if we're going to move something forward in there, we're going to want to have a little bit of something backing us up. Other than saying some of those statutes from the 1800s and 1900s are garbage.
Thanks. I think Lisa, you had your hand up.
I was just going to talk about the data for a moment, and thinking back to when the bill was written to establish the subcommittee and to review the misdemeanor system, period. The reason why that was, we all understood that there were some misdemeanors that were being charged more in some areas. There were some that were not being charged at all. There were some old ones. There were just disparities in the system that everyone agreed needed to be addressed. And the only way, in my mind, to identify those disparities effectively is to look at data. There are some that we can look at this list and off the top of our head and say, yeah, these probably should go. But then there are going to be some that when we look at the data, we're going to say, wow, I had no idea it was that bad. And so I think going back to what I said at the top of this meeting, establishing the process for how we review these misdemeanors, how we make our recommendations, we would be a better starting place than say, okay, how do we just tackle the list? I think just establish, and it sounds like it's just organically happening in the conversation that we're organically establishing some processes for these. But I think it's important that we do that. How are we going to make the recommendations for reform? How are we going to collect the data? What data points, which we've already talked about? But we already know the mission of this, but establishing the processes and what systems are we putting in place, I think would be a great place. Once we get those things established, at least in my mind, I think we'll make the rest of the conversation easier to have about what data points we need to collect and how we're going to make these recommendations. This is my thoughts.
Thanks. And so I've been attempting to take notes during this. So we've talked about and kind of talked, criteria for examining things. Are they antiquated? And then to a certain extent, to paraphrase James, is this on a basic policy level objectionable to this group? Like, is that, like those kind of determinations where, and that to me, that's a fine line. And that's maybe where I struggle with data versus policy and that kind of thing is this group comfortable with making some determinations that facially we don't think this misdemeanor is appropriate, and is that how we weed it out? And then we move on to the data. But we've got antiquated, we've talked about disproportionate enforcement. I'll use that as that's a big area, but I think generally we know what that means, geographically, community, demographics, is it disproportionately affecting one community of folks over another? Those kind of things. Are we charging, whatever misdemeanor a ton in Lincoln County, but not in Esmeralda County, for example. And, usually we pick on Clark and Washoe, so I figured I'd go somewhere else. Disproportionate enforcement, another criteria, and I have it written as policy versus data, trying to paraphrase or follow along with Mr. Conway and Lisa. And maybe that's is it facially objectionable to this group that exists as a potential crime? For example, on that list, NRS 331.200, if any of you come to the Capitol, Mr. Pirro, I'm looking in your direction, and you walk on the grass on Capitol grounds, that is technically a misdemeanor because it is a crime to walk on and damage any grass on state property. So again, do we facially think that that's just sort of silly? So maybe that's another criteria. And then, what other things, do we want to examine there? Because I'm sure there are more criteria on that, disproportionate enforcement. And then, for example, just listening to the discussion, obviously mental health is, it's hand in hand with some of this, but listening to the experts we have on this group, tracking that is going to be a challenge. So maybe that's not our first data point, and then you can look at usage rates and all sorts of stuff. But as we know, and Mr. Pirro indicated, Nevada's never been super great at collecting data, and there's some other services we are challenged in providing. So how do we reconcile that? And then Judge Higgins, and then Professor Hannon.
I read somewhere once the best way to eat an elephant is one bite at a time. So I think we got to figure out what our first 10 bites are. And I'm sure we could find 10 statutes that we all agree are problematical and get to work on pulling the data on those. The Court of Appeals just used a cannon to blow a hole through the obstructing and resisting statute. I'm not even sure what that statute means now after that opinion. And so that's been a catch-all for years. And so if we think that there's something is potentially being misused, that's probably a good candidate to pull the data on who is being charged for misdemeanor obstructing and resisting. And I'm sure between this group here, we could come up with 9 more that are the most likely culprits. I think we could spend all day long trying to parse out what are out of the hundreds of statutes, what are the 10. I think we just ought to pick some and get started one bite at a time. And Ms. Grosnick and the other public defenders probably know very well, probably better than I do, what people are commonly charged with, and is drug paraphernalia being overused? Is we have various. I think the loitering and the laws have gone away for the most part, but I think there are some of those status type statutes we should take a look at, and not try and fix the entire. We got 150 years worth of NRS we got to fix. So instead of trying to fix all those, and I think there's a hope that list we could just dump the entire list, is in my opinion. But as far as things that need to be taken a look at, that would be a place to start. And maybe we parse that out somehow, John, and get a little subcommittee going, and we all pick a page and we all agree on one thing on that page that needs to be looked at. But that's just my suggestion.
Thanks, Judge.
McCormick, I wasn't sure if you would call on me. I just unmuted myself, assuming I was next here. I think I'm hearing in this conversation that we have differing foci, and so focuses for this. So perhaps back to the working group idea, that would make sense. Like there are some which don't require data. You can just look and see, and we may have disagreements around the edges, but we may all be in agreement about many, such as on your list. But then it also sounds like there's a real interest in some goals which would require more data. And demographics by zip code seems very important to me for fines and fees, because you can correlate zip code to poverty, and you can see whether or not you have effectually a regressive taxation system, in some areas, which is important to do. So like for that working group, I'd assume that they would need more data. So I'm just floating it again to see if there's any interest in thinking in those terms.
Well, I appreciate that. And, not that I would ever voluntold anyone, but, maybe that is what we do here, is to develop sort of some of those working groups to start looking at it. We could have like Judge Higgins indicated, the collectively the most problematic misdemeanors, or at least perceived problematic misdemeanors from across our audience or membership here, to start pulling the data on, to start digging that way again. I think Judge Bishop was next. So
Judge Higgins talking about the paraphernalia kind of made me think of something. My paraphernalia charges have gone pretty high recently, but that is to benefit the defendants, because if the DA doesn't have the paraphernalia, then they're going to take the felony. And so we got to be careful that we don't cut off the ability to benefit the defendants with stuff like breach of peace, obstructing in lieu of like battery on an officer and stuff like that. If we start cutting too much, we're going to box people in and box them in from the bottom and push things up. So something to think about there and the unintended consequences.
all right, I think we got Marcy or Lisa next, whoever can unmute faster.
I can beat Lisa. Yay. So the one thing on a global level I was hoping we could look at is NRS 4.373 and NRS 5.055, talking about the length of suspension of a sentence. You know, when we look at the suspension of a sentence for a gross misdemeanor and a felony, the length of time that those sentences can be suspended is actually less than what we can suspend for a misdemeanor. So is it also appropriate for this group to determine what length of a suspended sentence is appropriate for certain cases and what that definition should be? Because it could be anywhere from 2 to 3 years based upon those statutes.
Lisa?
My thinking was going back to what Professor Hanan said about the working groups, and maybe thinking about establishing the working groups and then breaking this list up by chapters. It's a lot of chapters, but I think if we start and just break them up, like each group takes a particular set of chapters. There are some that are going to overlap, I think, and each group take a particular set of chapters, and we have our criteria and everything established. So we start going through those chapters, collecting the data on the offenses in those particular chapters, and then making the recommendations from there. I think that might, as Judge Higgins said, make our 10 bites a little bit more maybe palatable, but easier. At least we'll know where to start biting on the elephant. That's kind of what I'm thinking. I just wanted to pose that to the group and see, you know, what everyone else thought about that. And maybe that's where we start with, just breaking these out by chapters.
Well,
versus trying to go through these 1,000 misdemeanors and pick each one.
I certainly appreciate that, Lisa, because if it's not obvious to everybody, that's what I'm struggling with, is how do we get this bus moving? And so, yeah, I mean, if we want to break into to working groups, and I think that, you know, let's see, once we get up to maybe past, you know, get up towards the 600s, that may not be where we want to focus at this point, because that's sort of the individual employment type stuff and the regulatory. So, I mean, if that's something we want to do, you know, if we say, you know, we break into a few groups, and I don't know if you want to do that by audience or just randomly assigned or what, but to start looking at these and picking the ones that, you know, the groups think are certainly problematic. Because I'm looking at my list here of all the highlighted stuff that I worked on, and you know, there are some I had initially highlighted and then thought better of. So again, like I really kind of like Lisa's idea about breaking up in groups. I don't know if anybody has further thoughts on that.
I have a question to complicate and muddy the waters further, if that's okay.
Of course, that you know,
I was just curious whether or not there is a separate subcommittee, or if it's conceivably within the purview of this subcommittee, considering the issue of gross misdemeanors and felonies that maybe should be classified as misdemeanors. Because that's also a, you know, fairly significant issue within our criminal justice system. I don't know if someone else is looking at that. If so, we can leave it to them. But if nobody is looking at it, and if it's proper to be within the purview of this subcommittee, something we should also talk about considering.
Thanks, Mr. Conway. I certainly agree that that needs to be looked at, and I think that could be part of our charge. And as I recollect reading the bill, there's no end date on this. It can go on, so hopefully we can get started and then maybe look at that down the road, after we kind of to look at some of the misdemeanor stuff. Then we can go back and say, okay, so then on this list, we got a bunch of grosses. Why are some gross misdemeanors and why are some just regular misdemeanors? You know, and the whole thing, there's just so much to dig into, because if you look through the list, there are misdemeanors in this state that have a felony level monetary penalty attached to them. So, you know, in my mind, does that even still qualify as a misdemeanor? Because a misdemeanor is up to, unless specified by another statute, but you know, a $5,000 or a $10,000 fine by a misdemeanor, which is commensurate with a Cat C or a Cat B, seems sort of disproportionate. So, and again, I'll reiterate like that. I don't have the answer, but that's what I'm struggling with, is how we get going. And I'll come back, and I really do like Lisa's idea of sort of creating some working groups or individual tasks that you go through and you pick your top 10 that you want data on, you know, and we start from there, and then we can take advantage of our UNLV resource, and they can potentially look at other states and how they classify things, and we'll just kind of have that overview so we have that. But maybe that's what we do, and I don't want to make everybody stay on this meeting forever, because I don't know how many of you have been in a meeting chaired by former justices, which went forever and didn't have breaks. That's not, I learned that lesson. We're not doing that one. Anyways, just kidding. But so again, do we want to break it up by work group? Do we want to have everybody get a 85-page homework assignment to go through and find their top ones? Do we want to break? I mean, I don't know how useful it would be to break up by sort of profession area. I don't know if that makes sense, but we have the judges have a judge working group, and they identify their top 10. We have a prosecutorial working group, and they identify their top 10. We have a public defender. If does that create artificial division within the group? Because I mean, ideally, and I'd like us to sort of, have as much consensus as we can on this. And I'm not going to be naive and think everybody's going to agree on everything, but I would like to move in that direction. And I think that kind of lends itself to the next item on the agenda, which is broadly public safety misdemeanors. And oftentimes in these discussions, we talk about public safety and the interplay. And my thought there would be asking our folks on the prosecutorial side of the bar to identify those misdemeanors which they think are essential to that public safety function, so we're not running around in that way. So maybe we do have work groups by sort of profession, for lack of a better term, to identify the top misdos for each group, come back, discuss those, distill it into a list, and then send NDSP off into the data wasteland. I don't know if that works. Lisa, you have your hand up again?
You mentioned prosecutor, and it made me think of something. Having conversations with DA Wolfson here in Clark County about a year ago, that he had a list of things that his office just does not charge for. And maybe we reach out to the prosecutors across the state. Thinking about you mentioned prosecutors, just reach out to them and say, are there things that you all in your office don't charge for? I think that would be a good place to start, with some of those things that they just don't even charge for. At least it will give us something to look at. It will give us some charges that we can start with.
And I'm happy to do that. I'll reach out to the DA's Association and see if we can.
It also makes me think about where we're getting data from. So going back to the mental health piece, do we only have to get criminal data that's associated with mental health? Is there a way to get mental health records or hospital records that have that where a person who has been admitted or who has been treated has had some interaction with the criminal legal system? Is that a possibility? I don't know. I'm asking the attorneys and the judges on the call, but I'm just wanting to think about where we're going to be getting data from, and where are some other places that we could get data that might be a little bit easier to get than just through NSDP.
I'm just going to jump in and say you're not going to be able to get health data like that.
Okay.
You're just not.
Well, and I think, I mean, not to get too sideways here, and Judge Higgins just popped something up in the notes that I think is worth looking at. And I totally forgot what my point was. So anyways, but again, yeah, it was on the competency stuff, because that even is not the most clear thing in statute, because district court has jurisdiction to determine competency, and then there's some mention of it in some of the other statutes. And so again, I think to get started, the mental health aspect may be not the first thing to take on, because it is such a complex issue, and we'll get sort of, sidetracked there. So again, I mean, I keep coming back to it, but I think, do we want to divide into, or do we have some other criteria for the different groups? Regionally, do we just volunteers? I mean, do we do the elementary school thing and I go down the list and go 1, 2, 3, 4, and that's the group to look at that? Director Powers?
Thank you. I just want to go back to talking about the data piece for a minute and where we're going to get it. We all hope that, arrests are made and across the state, everyone does things the same. There's boxes that are checked and forms to be filled out. And right now I'm going to talk from a felony standpoint, because that's where most of the data that we have prior to this subcommittee, came from. We have a lot of DOC data, but we have struggled to get data from arresting agencies, from things like that. Had very long conversations with people. People tend not to want to share, at least somewhere where it's going to end up in a public forum, because their data may be misconstrued, right? They want to be able to tell their story. And so I just want to throw out there that getting all of this data is going to be much more difficult than we wish, or that it seems, or that this discussion makes me feel like people think it's going to be. So I'm just going to throw that out there. And then mental health, I will say it's going to be difficult with arrests and such, but I think when we first talked about that, it was regarding incarceration, so in the jail populations. And we can't say this is what their diagnosis is, but we can get data that says they have the mental health box checked. So.
All right, Judge Bishop.
So I think probably breaking it up by practice area is a good idea. I've looked at the judges here. We've got Vegas, we've got Washington, we've got rural, and I imagine we could probably come to a pretty decent consensus of 5 to 10 that we think should go. And the public defenders are going to have similar cross-jurisdictional, cross-geographical concerns. And that might be the way to do it. Then we bring them all together, and then like the DEA can tell us why we're not trying to want to get rid of that one, and the public defenders can tell us why that this one's really important to go. But I don't see any other way of breaking it up. And getting the data, yeah, I mean, we all have that lies, damn lies, and statistics. As soon as you guys get the numbers, we don't get to control the data. You could make us look really bad by using the statistics. So I get the concern that you're getting there and the pushback. We maybe need to use this with some of that low-hanging fruit to kind of build some credibility. We're not going to screw people that way.
Appreciate that, Judge. Jenna, I think you had your hand up.
Hi, yes, I did. Jenna Bonacorsi. Just jumping off of what Georgia was talking about with data, and like she said, we've spent a lot of time working with felony data, because that's what with AB 236 and a lot of those things, that's where a lot of it came from. And the other point we have to consider, and I know this was kind of mentioned earlier, is that Nevada has struggled to be data-driven due to the infrastructure of the systems collecting data. These offender tracking systems or jail tracking systems or whatever it might be, they were designed, and a lot of the ones in play are 20 plus years old. They were designed for the purpose of tracking information at that point in time. Where the challenge arises is pulling historical data now, when the systems weren't necessarily designed to do that. And so, yes, some of this information I think we need to keep in mind is this something that we need to make sure we start tracking further on, and then narrowing down who is tracking it. And off of George's point, are they going to be willing to share it in the first place? But that's been one of the biggest struggles. Some of these agencies are willing to share this information with us. They just don't have the actual technical ability to extract data in the way that is needed, especially when you're trying to create a historical baseline or show a trend in what has been happening in the history. And so that's just one challenge when we narrow down what points we want to look at. Those will be a couple things that we'll have to take into consideration once we start collecting the data. I guess just because it's tracked doesn't mean it's extractable.
I think we've got Professor Hannon next, and then Ms. Grosnick.
Yeah, thank you. So thinking about like the working groups and whether it's by practice area or not, I don't have such much of an opinion on that, but I think it'd be helpful to have a few criteria, like just to flag things for, like, looks like it might be a constitutional issue, or 3 question marks in a row, I can't believe this is a crime, or this is a standard misdemeanor, but it's saying that the fees, the fines can be over 1,000, or the punishment has a mandatory day on it. And then once we have things sort of chunked out like that, like these are the oddballs where it could be $5,000, $10,000 fine. That's weird, as you pointed out, Chair McCormick, or, this over here has really vague language, and it's maybe even been the subject of Nevada Supreme Court litigation. We could have kind of areas that would be easier to deal with, and some of those areas would need data, and others, might be something that's more of more analytic than needing data to get rid of, or to think about whether it needs to be modified. So I don't know if that's doing something more like dividing up the pages and each group looking through them, or if you'd rather have volunteers to volunteer to do certain things and then see if others would join those people. I know we're all busy, right? As an academic in the summer, I'm a little less busy, which is why I'm coming out strong here. I'm saying I can do a few things here if needed, but I don't know if that helps.
I certainly appreciate it, and I think that's very valuable. What I was just, and get to in just a sec, Evie, I was just writing down work groups. Like, do we have them do their, what are your top 5 criteria for considering, why are you considering this? Why is this in your top misdemeanor? Is it because you think it's overcharged? Is it that? Do we need data? What are the, and then the top 10 misdos from the list. So does every group go through and identify that stuff to start with to give us a starting point? Evie?
Thanks. And I saw James trying to jump in, so I just wanted to let him know it's the button that says reactions down at the bottom. That's where your raise your hand button is. I had 2 thoughts. One is maybe one of our first recommendations to the Nevada Sentencing Commission would be to either encourage or suggest mandatory data reporting requirements. And I think we can also probably look, and I'm sorry this comment's a little bit late, it's just hard, the conversation kind of goes in pieces. We could potentially get some of this information from other sources, right? Like most counties track how much money they're owed by court order, I would imagine. They keep track of what should be coming in. They keep track monetarily of what has come in. I know DIDS collects money on what is spent on indigent defense. So if you want to know, proportionately how much money is coming in from indigent clients, you could look at rates of like public defender appointment. Public defenders are appointed in 89% of cases, say, and then look at how much money is actually collected from fines and fees and get a better idea maybe of how much is being charged to indigent defendants. You could kind of go around if certain places aren't collecting some kind of data, we might be able to get it from other places.
Appreciate it. Thank you. And
That's the problem. I don't have the reactions button
sorry,
for
go
some
for it.
reason. I don't know why. I think I might be in as a guest rather than a member for some reason, but
Yeah.
so if I keep butting in, I apologize, but I can't find my reactions button.
It's in the more, James, on mine.
And please feel free. I'm just trying to watch everybody's screen. So if I'm missing people and going out of order, that is entirely a function of my humanity.
I found it. See, I just gave a thumbs up. Thank you, Judge Bishop.
We're kind of going to be butting up against time here if we're going to, I mean, we've got, did you say, Judge Higgins, August?
Well, if it involves a BDR, yes, August.
Well, and that depends on 218D and who's doing the BDR and all that sort of stuff. So it's not, say, as hard and fast as, say, the AG's office or the judicial branch that gets allotted a specific number that must be pre-filed on or before September 1st of the year immediately preceding a session.
Well, maybe September then, but we've got less than 6 months.
Right.
If we're going to do a bill draft of any sort.
I think we should break up into practice areas and then we come back with our 5. And then if we explain we didn't like this because it's a constitutional issue, and then, or we can't even read it without kind of snickering because it's silliness or whatever factors they are. And then when the DAs and the PDs and the other groups come back and they have the same reasons, then we'll have a pretty good idea of what criteria we should be looking at. And they give us a way to kind of start even harder. But I mean, we got to kind of come up with some of them, and sitting here and discussing them, I don't know that's going to be that productive.
Right. I certainly agree, Judge. And I think as Lisa's suggestion, you've suggested, maybe that is the starting place, is practice work groups. Go through the list and pick your top 10 that you want data on. And then if you can articulate, your criteria for either picking those for data or why you would recommend something else be removed, whether it's facially, potentially facially unconstitutional or any of that. And then does that get our diverse sort of stakeholder groups comparing apples to apples? Because, I feel somewhat responsible. This is a lot of theoretical sort of discussion because the issue is so big, or the body of information, maybe not the issue, but the body of information to look at is pretty huge.
Are we just talking the 3-page list here, or are we talking the giant list of all misdemeanors?
If we're going to talk about data, I think we have to talk about the giant list, because on the more abbreviated list that I created, I mean, I'm fairly confident a lot of those ain't been charged in 100 years. So there's not going to be any data to collect if we want it. Mr. Pirro.
I think we found a pretty good place to start. I think, yes, the big list, I think breaking up into groups, and that'll give us at least something. And then kind of when we regroup, then we're going to have probably more robust discussion. But I think I agree with kind of the consensus of the group that we should move forward in groups and look at that big list and start breaking it down in teams.
All right. Well, so, I mean, that does sound like a path forward. I don't know if we need a motion to do that, or if we just, because it's not necessarily an official action to break into subcommittees to look at things. But again, hopefully somebody can help me out on that one, Jack.
Yeah, I'm a big fan of the direction we're going. I think we need to go that way, but I really think each group needs to just kind of know exactly, we're going through the list, what exactly are we doing with the list, because otherwise we're all going to go in different directions, and it'll take us, if we can define it now, it'll save a lot of time in the future.
Okay. So if I can, and please feel free to jump in here, I'm going to try to recap. I mean, is it, we go through the list and each subject matter expert group picks, these are the 10 misdemeanors we want data on. These are the 10, and it doesn't have to be a specified number. I mean, I think the data one would be better if we could confine it to a reasonable, these are the top 10 we want to really start looking at data on. These are the 27 we think are facially silly, and then what each group, maybe, because we talked about the criteria for moving forward and making our assessment. And maybe that's how we really start to develop that, just not from my notes, but each group come up with, these are our top 5 criteria that we think we should be using to evaluate misdemeanors or evaluate the work of the committee to move forward. So then, we can get everybody on one page. So if that, is that a reasonable charge to pick the top 10 misdos you want data on? Royal, you obviously, and then whatever number of misdemeanors you think are just facially inappropriate at this juncture, and do we limit that? And then have each group develop, sort of the criteria that they would like to look at after we get the data and examine this stuff for examining the whole thing. I see Mr. Pirro shaking his head. If the group's comfortable with that, and Professor, I think, certainly involved in that, but also if you have the capacity to start looking at some of that outside stuff, like what other states do, I would certainly be interested in, the classifications, and then what other maximum penalties are. And then I think going back to Marcy's question, misdemeanor probation systems, how does that vary from state to state? Because Nevada it's all over the board. We've got some jurisdictions that have a Department of Alternative Sentencing, or that's engaged even on the pretrial end. And then we have other jurisdictions where they don't have that, and there's numerous status checks on the back end of the case. So if we could, if you wouldn't mind looking at that, and Mr. Pirro, are you hand up again or just never took down? Okay.
Never took it down. Sorry, John.
All right. No worries. So, among the group, and Lisa, certainly asking for your thoughts, what if we identify our top 10 that we want a data pull on, and then identify the criteria with which we want to examine misdemeanors from the perspective of each group, so we can marry that up and come up with a master list. And then, how many ever number, I think that this is probably the least important, or not least important, but easier category, how many facially we think, the offenses you think facially should not be an offense. If those are the 3 tasks for the group and they go through, we all go through the full list, then I think we could come back together and hopefully, fingers crossed here, we see that we're not that far apart on some of this, and that'll really give us a starting place. And again, just for me, and taking a moment of privilege, I really appreciate this conversation, because I've had such a hard time figuring out how to start, Professor.
Sure. Yeah, thank you. This is a huge task, so it does help to sort out in this way. Could we get a reminder either on this call or by email about when you would need any material that could be, if this results in anybody making a list on paper that would need to be submitted in time under the public meeting laws, so that it can be included? I need a due date or it doesn't get done.
No, of course I get it. And it's what the agenda has to be posted 3 days, and materials posted 3 days before the date of the meeting. So whenever the next meeting is, so that would be June 14th. And I don't, if that's not enough time, then we do it at the July 24th meeting, where we bring all this stuff back. Lisa?
Regarding the working groups, I think I am in agreement with you, but maybe just in a different order. I'm thinking that when we establish the working groups and we break this out by chapter, we go through and look at the ones that are antiquated first and just get rid of those, or make the recommendation. And then look at the ones that, as you say, are facially, I forgot what the terminology was that you used.
I think something like, I said, like facially problematic, or some sort of nebulous term.
Yep. So we look at the ones that are antiquated and then go through and look at those ones that you suggested. And then from there, we can look through and see which ones we need data on. I think that'll just eliminate a lot of these that we'll have to ask for data on, get data on, and then, or find the ones that we don't have data on. I think that's going to be important for us also. When we make our recommendations, I think someone mentioned it a little while ago, that be one of our recommendations, that we need some more solid systems in place to be able to collect data. And we've tried to, John, we've tried to do that before. And both Johns, we've tried to do that before.
Oh, yeah.
Yeah, and so maybe that's, one of our recommendations that come out. But I think we start there. Working groups, break this out by chapter, go through and see which ones are antiquated, which ones have never, because your notes on the side are good, which ones have never been used, never been charged, never been amended, and then look at the ones that kind of just facially like, yeah, that probably shouldn't be there, and eliminate those, and then go and make the data request from there. That will eliminate us having to get these huge data requests.
Yeah, I really like that. I appreciate it, Lisa, because that's a good way to do it. So if we charge each group with coming up their list of antiquated, facially problematic, ones that we need data on, and then sort of their consensus criteria for examining it going forward. Does that sound like a fair charge? And yeah, June 14 seems pretty quick for that if we're giving everybody a giant homework assignment. So if that works for July 24, and then Director Powers.
We were talking about open meeting. Can we close agenda item 5? And then I think we're basically tabling 6 at this point, open 7, and I think everything we're talking about, it fits right there.
All right, thank you. Appreciate that, Director Powers. We will close agenda item number 5 regarding data requests. We will table number 6 based upon the discussion, and then we will be on number 7, which is the subcommittee focus. And I think that's what we're talking about now, with breaking apart into practice work groups, and each group coming up with its antiquated, facially problematic, really want the data on these, and then the criteria for considering things going forward as the charge, and then however the group wants to present that. Is that fair to say?
Donna? Sure, I have a question regarding open meeting laws. If we are breaking up, first of all, let me say, when I was thinking about working groups, I was thinking about establishing the working groups as it is outlined with the bill and in the statute,
right.
Which would mean appointing other people that are not part of the subcommittee as a working group. The second question I have is, if we do it this way, where we're breaking out as a subcommittee into groups, would that be violating any open meeting laws?
My understanding of SB 103 is that any working groups we make are not subject to open meeting law, and they may include. So I believe it's a permissive inclusion of other folks, but if it's just made up with groups here, that those individual meetings don't have to be open meeting. So we've been talking for an hour and a half, and I would assume people are getting kind of tired of hearing us collectively. So maybe
quick question, John?
Yes, sir. Did
you send out the great big giant list of misdemeanors at one point?
I think we did, but
is it from the Sentencing Commission, or is it from you?
It's from it should have come from NDSP, and it's
okay. I'll look for it under that. Ms. Powers is nodding her head, so I will look for it under that.
Research division. So my proposal at this point would be I will develop, sort of the ask for the working groups, and we'll send that out with this. And then I don't know if you want NDSP and I to assign the working groups, or if we want to kind of break up to those organically, or how we want to do that. That's the last, I think, outstanding question. If we've got our charge and our timeline and the information to send out. And Director Powers?
Sorry. I just wanted one caveat with the working groups and the open meeting law. I think because there are going to be so many working groups, we'll be fine, but the working groups could not include more than half of our members in one working group.
Sounds good, and hopefully we put the committee together in a way that we wouldn't have more than half of anybody in any one group, because I think we have pretty decent representation. So I don't know if we want to talk about breaking the groups. If you want me and NDSP to take a run at that and send it out, if you want to organically do it, that's the only thing left. I mean, like, the judge working group is pretty easy to figure out who's on that one. But again, so I think that's the remaining question.
I think, keeping it the judges, keeping it the district attorneys and city attorneys, and then keeping it the public defenders with Lisa and Professor Eve works for me.
I'm comfortable with that, and then we'll also have court administrators, and I think the question there is, do court administrators join the judges, or do we have two different groups? Because, I mean, this is me having worked in the judicial branch for a while. I'm sure that court administrators and judges don't always see eye to eye, and there may be different focuses for those groups from, you know, an administrative standpoint versus that. So if we do court administrators, public defenders, prosecutorial, and judicial, I think that would cover everybody. And then, you know, like, we do have staff support from NDSP, but again, if we're breaking into all these groups, and you know, we can kind of work on logistics on that on the back end. But if everyone's comfortable with that, I will crank out something with the sort of what we've talked about and what we're desirous of, provide the list, and then provide what I perceive to be the group roster. We'll send that out to everybody, try to turn that around pretty quickly, and then come back and then get started. And then, you know, we can talk about the July 24th meeting. And I think as a group, if we determine that this is the substantive work, you know, maybe we don't need that June 14th meeting. And in lieu of that, we do the nitty gritty with the individualized groups. All right, I got a thumbs up from Judge Cruz. Cool, that sounds great. Jordan, Director Powers, do we need a motion on that, or can that kind of be a consensus moving forward?
Let's go ahead and do a motion of having the working groups and that they will be broken out as we have discussed.
All right, I will entertain such a motion.
So moved.
I have a motion from, yes, a motion, yeah. Judge Bishop has moved. And do I have a second?
Second.
Jack Esslinger, second.
All right, we got all sorts of seconds here. So Jack identified himself, so I'll give him the second. All those in favor?
Aye.
Aye.
Opposed?
Aye.
Cool. All right, I will endeavor to get that done here as soon as possible, get it out so we can all start working. You know, and again, it's a big task, and it's kind of complicated and nebulous, and I really appreciate everybody's engagement. And, you know, I think the importance of this, and the fact that it's time to start dealing with it. So, again, if nothing more on that, we've got, we'll close agenda item number 7, which is, you know, not nebulous at all, but subcommittee focus, and move on to 8 potential topics and dates for future meeting. I think we've sort of handled that together with that last motion. And I think as we get closer to that proposed June 14th and enough time to give NDSP a chance to do stuff, we can kind of make that determination depending on how the subcommittees feel like they're doing. And then certainly shoot for that July 24 meeting for the due date for the subcommittee work. I think that should give everybody a pretty good amount of time to do it and not rushed. And I promise those judges who are at the, you know, I mean, maybe we can do that at the limited jurisdiction seminar. It'll be fun. So with that, unless anybody has anything else on those, I will move to agenda item number 9, which was our second period of public comment. As I indicated previously, you know, there are 2 ways for people to submit public comment. First one is via writing to the Nevada Department of Sentencing Policy. Second is to provide testimony via phone. And so that public comment on the phone may be limited to 2 minutes, and I will ask Ms. Jones if we have anybody on the line.
We do not have anyone on the line right now.
All right, excellent. Hearing no public comment, we'll move on to agenda item 10, which is adjournment, and we will be sending out your not inconsequential homework assignment here shortly. So again, really appreciate everybody's time and attention on this, and helping us figure out where we're going and what we're doing. So thank you.
Thank you.
Aye.
Thank you.